IPCO Nigeria Limited.
May it please the Court. In this appeal, I and Mr. James Willen appear for the appellant NNPC, and learned friends Mr. Michael Black QC and Mr. Edward Knight appear for the respondent IPCO. Lords, this is an appeal from the Court of Appeal decision 10th of November 2015. You'll have in the papers a Court of Appeal order, a judgment, and a supplementary judgment.
Well, I think you can take it. We've got our head round most of that.
I'm grateful for that because, of course, this is a long, long history in this case.
And, we haven't necessarily got our head round the whole history, but...
The appeal arises out of IPCO's claim to enforce the Nigerian arbitration award, and it also arises out of my client's position that the award was procured by IPCO's fraud, as well as some non-fraud defences. Amidst this mass of detail, there is one core point. The core point, in fact the only point for this court now, is the basis upon which a condition was imposed by the Court of Appeal that security of $100 million be paid as the price for NNPC to defend itself under Article 5 of the New York Convention.
That's the additional
That's what they
price.
did.
Yes.
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 If that's what they did.
If that's what they did, exactly. So that takes me then to break it down into three parts. The first one is that what happened? First point is a preliminary issue. Was this an order, in fact, under Section 103.5, contrary to my client's case, as opposed to 103.3? That's the first point. If indeed it was not under 103.5 or not properly under 103.5, the next question is, where did the power come from? Is it within 103.3? Is it the CPR 3.1? And then the last stage of the argument is, if indeed there is such a power, then as a point of principle, was it properly implemented? Was the discretion properly exercised in this case? So, my lords, with the court's leave, I propose to address it in this order. There are some points of background which I want to briefly highlight. I'm not going to go through the whole history because we only have one day. So I'm going to start with some points of brief background which are salient to the issues that are before you. Secondly, I'll address the preliminary issue. That is, was this an order under Section 103.5? Thirdly, assuming that it was not under 103.5, I'm then going to address where else did it come from, 103.3 or CPR 3.1. And then lastly, I'll get to points of principle. Before I launch into that, can I just, as a matter of housekeeping, point out with an apology to the court and an apology I've given to my learned friend, there are two additional volumes which I hope have got to your lordships. One is an additional volume 2, which has got two further documents in it.
Yes. Mm-hmm.
And the second volume is a third volume of Authorities yep. Volume 3.
Yes.
I understand my learned friend's not opposing, although he may want to have time, if necessary, to address any further issues from that material. Can I then start with the first part, which is the relevant background? There's been a long and complex history, both in Nigeria and in England. That is narrated in paragraphs 3 to 87, 24 pages of the Court of Appeal main judgment. I'm going to highlight just a few salient points. Firstly, some points about the nature of the underlying dispute and the award, very briefly. Secondly, the nature of the defences, non-fraud defences and the fraud defence. And then just to set the procedural scene briefly about the various English proceedings. Just the context, that's all. So let me start on that. In terms of the underlying dispute, this is a dispute between two Nigerian entities. IPCO is a Nigerian corporation, albeit member of a Hong Kong group of companies, NNPC, obviously Nigerian. This, in fact, when Mr. Justice Gross, many years ago, rendered his first judgment in this case, it was one of the first instances where the New York Convention had been applied to two entities of the same nationality. It's a Nigerian against a Nigerian entity. And he held that there's no nationality restriction or requirement in the New York Convention, so notwithstanding that it's an inter-Nigerian dispute, it comes within the New York Convention. The contract out of which the dispute arose was 14th of March 1994. It's governed by Nigerian law. It contains a choice of Nigerian arbitration with Nigerian seat. And so the parties were contracting into the Nigerian legal system as the curial court, the supervising court. Disputes arose, February 2003, notice of arbitration, the award then 28th of October 2004, and a principal sum awarded to IPCO of approximately $152 million. Now, can I turn to the nature of the defences that have been raised along the way by NNPC? As set out by the Court of Appeal, there are two categories of defence, obviously. Non-fraud defences and then fraud defences. For each of those, there has been a mass of satellite litigation in Nigeria. Multiple interlocutory fights initiated by both parties. There have been extraordinary court delays. There have been extraordinary inefficiencies. There has been no resolution in Nigeria. But the important point for my purposes is that having heard all the detail, having heard criticism of my client made by IPCO, and no doubt criticism by my client of IPCO, the basis upon which the Court of Appeal proceeded, which is all that is of interest to this court now, was that it was not prepared to make findings as to any party's responsibility or to apportion blame for what has taken place. That is a point I'd like to...
Procedurally in Nigeria.
Yes, yes. It's a point which will be of obvious relevance when one's considering where the condition lies. So for that, can I take your lordships to the Court of Appeal judgment?
There's a paragraph, isn't there?
There are a couple of paragraphs I just want to quickly point to. First, you'll have that in the core bundle at tab 8 sub B. It's MS page, starts at MS page 119. I'd like to go to paragraphs 164, 165, MS page 160. And of course, all one's concerned with is what was the basis upon which the Court of Appeal proceeded and imposed the condition. So 164, Lord Justice Christopher Clark, I do not find it profitable to seek to determine which party, if either, is more to blame for the delay, which appears to me in large measure to result from the workings of the Nigerian legal system. And then paragraph 165, about 5 lines from the bottom, no attempt appears to have been made by the parties to secure an early determination of either the non-fraud or the fraud allegation, or of NNPC's entitlement to make them, or any consolidation of the two. This may well be because, as Justice Esso had said in his evidence, there was no real prospect of an accelerated hearing of any appeal or application. And then just one other point, just because it's rather graphic, paragraph 172 over the page. I am conscious of the need for comity between the courts of friendly foreign states, especially when the court in question is the court of the seat of the arbitration to which the parties agreed. But, and I intend no disrespect whatever to the judges of the Federal Republic of Nigeria, the plain fact of the matter is that the operation of the judicial system in Nigeria has not kept pace with the need to give effect to the principles underlying the New York Convention. I won't read the whole of the paragraph, but the last sentence ends with saying that the process is sclerotic. So that is the, in terms of blame and responsibility, should, in my submission, sweep away a lot of issues that the other side may want to pursue as to who was right and who was wrong, because that Court of Appeal wasn't proceeding on that basis. Can I then turn to just briefly look at the nature of firstly, the non-fraud defences and then the fraud defences? For the non...
Why does it matter? We've got a clear finding that you've got a reasonable case, I think, on each, and some of us may have, I think probably all of us are familiar with the nature of the defences in general terms. The fraud ones are rather well set out in judgment, and it's not disputed that they give rise to a bona fide arguable defence.
Then I can move straight on. In fact, the only...
Colleagues want to carry it further.
No, I mean, so that was the point I was going to make was the strength of each. So we've got the gross finding, which is recited in the Court of Appeal judgment, that the non-fraud issues are arguable. And then when one turns to the fraud issue, there's been a big fight between the parties at IPCO's instance to say that there has been a reduction in plausibility of the fraud, which was their grounds to try and open the consent order. And that was fought hard in front of the Court of Appeal, and the Court of Appeal has disagreed and has said, if anything, in one comment, part of the fraud case may have improved, and ultimately the...
Where do they say that?
All right, so can I, if I just give, I'll just give you the references. The finding, which actually is an important finding for my purposes, where this started, is actually in the judgment of Field J, paragraph 94. Can I just start there?
Yes, well, that's the one I've heavily highlighted.
Yes. So that is Core Bundle 8, sub E. And Mr. Justice Field said paragraph 94.
Which?
Paragraph 94. So it's Core Bundle,
Okay.
MS 204. Paragraph 94. At the hearing, NNPC's fraud case was investigated against the possibility that the court would be satisfied that the court should consider enforcement of the award afresh. And having considered this aspect of the case, I can say that even if I had been persuaded that it were appropriate to consider enforcement afresh, I would still have refused to enforce any part of the award, because in my opinion, NNPC have a good prima facie case that IPCO practiced a fraud on the tribunal which undermines the validity of the whole award. And just to complete that, at Mr. Justice Field's paragraph 111, MS 207, in my judgment, the evidence presented by IPCO and the submissions made by Mr. Black do not demonstrate that NNPC's fraud allegations are unsustainable or constitute only a very weak case. On the contrary, I conclude that NNPC has established a good prima facie case that is fit to go to trial in Nigeria with the benefit of full discovery and the cross-examination of the various witnesses. So that's the starting point. There was an attempt, valiant, hard-fought attempt by IPCO to question that in the Court of Appeal. That was gone through, as you would have seen, in exhaustive and indeed exhausting detail. The Court of Appeal then rejected the argument that things had got worse, and the relevant passages, if I can take you to that judgment. So it's Core Bundle 8 sub B, paragraph 134. To start with, 134, 135, 136. So 134.
So what, MS page?
MS 154.
136, isn't it?
It's 136, but the particular reference to improvement is 135.
Yes.
So in other words, I won't read those out, unless that's helpful.
No, well, I mean...
And then 168.
I'm sorry, I'm not sure that I'm in the right place.
Can I then...
What's the MS number of the page?
Yeah, so MS 154.
Aha.
Sorry, I'm taking this at speed, just...
Yes. If you gave the MS numbers, it's quicker to find.
Yes. So MS 154, paragraph 134, sets out the reasons why IPCO had said plausibility had reduced over time. And then 135, against that, there is the material which the judge took into account and to which I have referred to at 105 to 116 above. These matters, arising for the most part after the date of the consent order, seem to me to have improved NNPC's case on fraud. Further, the POF, which are the particulars of fraud, were based almost exclusively on documentary evidence which has not changed since the consent order. And then 136, if I consider the strength of the case for challenging the award on the grounds of fraud without reference to other considerations, it does not seem to me the judge was in error in deciding that there was insufficient grounds to exercise a discretion afresh and to do so in IPCO's favour. Just going down to the third line from the bottom, there remains a good prima facie case that the award was in part obtained by fraud. The grounds of appeal do not claim that there was not. And then at paragraph 168, which is MS 161, That was obviously a point which was important to the Court of Appeal in deciding what to do in this case. 168, what then are we to do? We're faced with a stark choice. If we order that the award be enforced, the enforcement may well be successful and will certainly be successful as to 80 million. If it is, the prospect of NNPC recovering the amount paid if the award is in the end set aside in Nigeria is practically non-existent. That may mean that IPCO receives payment under an award which it obtained by fraud. I agree with the submission of NNPC that this is a course which the court should be deeply reluctant to take. And then lastly, on this point, 182, which is MS 163, this is where the point is extended to the whole award. 182, I have, however, come to the conclusion that in circumstances where there is a viable challenge to the whole award, it is inappropriate to order any part of it to be paid, and that an increase in security alone does not address the real problem. My learned friend's written case begins, paragraph 6, with some pejorative remarks about the evidence or the witnesses with respect to fraud. It's not a proper approach in my respectful submission, because we are basing ourselves on what the Court of Appeal has done. The Court of Appeal has proceeded on the basis that there is a good arguable case, prima facie case of fraud. And so this is where, you'll see why I'm emphasizing that, my client's in the position where it now has to put up $100 million in order to argue that case of fraud. What having now just outlined the defences, I was going to just set the scene for the English procedure. Maybe I don't need to. In broad terms, 3 attempts over the years to secure recognition and enforcement in England.
And you, on at least 2 occasions, when security was ordered and increased, resisted those attempts to have immediate recognition enforcement on the basis that the matter should await
Yes.
the Nigerian proceedings.
Yes.
And so 80 million is already in the bank.
Yes.
We'll come back to that, no doubt. But we're now concerned with the last phase.
Yes. And so what's changed is, if I can I'll just bridge this totally, that the situation led to, when the fraud issue arose, it led to a consent order. The consent order
Stay pending the Nigerian proceedings. Yes.
And that is the starting point for this process now, because the consent order having been concluded, and before the consent order had been put in place, my client had been applying under Section 103(3) that the award should not be recognised and enforced on public policy grounds because of fraud, and also as an alternative 103(5), stay pending Nigeria. You then get the consent order, which is everything will go off to Nigeria. The years then roll by, and it's IPCO that then comes back on the 3rd phase before the English court, and it's IPCO that then is seeking to persuade the court to reopen the consent order because of changed circumstances. And the changed circumstances were its argument, which failed, that fraud had become less plausible in the meantime, and secondly, the extent and nature of the delay. And that's what seems to have motivated the Court of Appeal.
Yes.
Well, I think that's probably what I need to say on the procedural setting. And I don't think I can summarize briefly what the Court of Appeal did, but obviously I have to come back in detail in the course of my argument to show how it reasoned on each stage.
Well, the Court of Appeal, on the face of it, lifted the stay on the ground you just mentioned, and contemplated, put it neutrally, that the English courts would now, I think in part by consent, determine everything.
Yes, exactly. Now, and at that point, it was just the fraud allegations, because what the Court of Appeal did was they swept away the
Originally just fraud, now it's everything.
Exactly.
Yeah.
Exactly. So, my Lord, I think, can I then turn to the next stage before I get to the first preliminary issue and just remind your Lordships of the key legislative provisions at stake? I know this will be familiar to the Court, but just by way of a reminder as to how this part of the 1996 Act works. Your Lordships will find the relevant sections of the 1996 Act in the First Authorities Bundle, Volume 1. And if I can ask your Lordships to have open also the Second Authorities Bundle at tab 22, which are the corresponding provisions of the New York Convention. The relevant sections of the Act are in Part 3, that starts at MS 481. Obviously, sections 100 to 103 of our Act implement the 1958 New York Convention. Section 102, sorry, I'll start with section 101. Section 101, sub 2, provides that a New York Convention award will be enforced with leave of the court in the same manner as a judgment, and 1013 permits judgment to be entered in the terms of the award where leave is so given. Those two provisions are implementing Article 3 of the New York Convention. And you'll see that in Authorities Bundle 2, tab 22, MS 868. The first sentence, each contracting state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon, under the conditions laid down in the following articles. Then section 102 of the 96 Act is the evidence which is to be provided in the course of this process, and that in terms replicates Article 4 of the New York Convention. And then we get to sections 103, 1 and 2. These are both grounds for refusing recognition and enforcement at the request of a party. And that is Article 5 of the New York Convention in terms.
Rather distractingly, section 103, 2A and B, in fact, implements Article 5A.
Yes.
So that the numbering or the lettering gets out of sync.
And that was the fault of those who drafted the 1975 Arbitration Act. Because I'm going to put on record, because all that happened here was that the 75 Act was repeated in Part 3.
Yes, I see.
Yeah, except that some of the other offending bits were taken out.
No, otherwise it's all the same.
It's all the same. The important point at the moment is 103, 1 and 2 are grounds which are at a requesting party's initiation. So somebody comes to the court and seeks to raise this defense. Then you have 1033, which is Article 5.2 of the New York Convention. And that is the ground which is relevant for us. Recognition or enforcement of the award may also be refused if the award is in respect of a matter which is not capable of settlement by arbitration, or if it would be contrary to public policy to recognize or enforce the award, which of course includes an award having been procured by fraud. Unlike the previous sections, this is a defense that can be raised by a party or by the court of its own motion. And then you have...
This is the public policy of the enforcing courts.
Yes, exactly. There's a whole debate about English international public policy, but essentially, yes.
That's stated expressly in the New York Convention,
yes.
Isn't it?
Yeah. No, a New York Convention has the same language. I mean, one can see it.
No, it says contrary to the public policy of that country.
Of that country.
That's the country where recognition or
Yes.
an enforcement is sought.
Yeah. Then we have section 103.5, and that is, of course, of particular relevance for us. And this encapsulates Article 6 of the New York Convention. 103.5 is of a different nature to the other provisions. This is not a ground for refusing recognition and enforcement. It is simply a decision to adjourn, importantly, the decision about recognition and enforcement. That's a very important distinction. What 1035 is doing is saying that it allows the court not to make the decision about recognition or enforcement, but to wait and see what might happen before the curial court abroad. That is exactly what Article 6 of the New York Convention says. So it's got to be read together with that. Members, can I then turn to the preliminary issue as the first of the substantive points? It's IPCO's case that no condition was imposed on NNPC's right to advance a defence under Section 1033 because the condition was imposed under 1035. We say that is plainly not what happened in this case, and that can be shown by reference to 3 points. I'll just quickly identify what the 3 points are that I would like to cover in this context. Firstly, one needs to look at what the Court of Appeal's order actually was. Secondly, we need to look at what reliance can be placed on Section 1035 in any event. What use can 1035 be put to? And thirdly, we need to look at the authority on 1035 and its scope and nature. In terms of the first of those, the Court of Appeal's order, can I ask your Lordships to turn up that which is in the core bundle at tab 8A. It's MS 116. It is absolutely clear in my submission. The Court of Appeal was imposing security as a condition of NNPC's right to have any determination of its public policy defence. So the relevant part was the second order, Order 2. Upon condition that the respondent provides security as set out at paragraph 5 below, A, the proceedings shall be remitted to the commercial court for determination, pursuant to Section 1033 of the Act, as to whether the arbitral award dated 28th of October 2004 should not be enforced in whole or in part because it would be against English public policy so to do. Now, just pausing there before we get to the next subsection, on any view, that is not what Section 1035 is about. This is not about adjourning the decision on recognition and enforcement and waiting and seeing. This is about actively referring that determination now to the commercial court to be done now, on condition of payment of security.
It's not an adjournment at all.
No, it's not an adjournment at all.
And if it's an adjournment, it's not an adjournment for the purpose specified in sub 5.
That's it. Exactly.
Well, I mean, we shall no doubt adjourn for lunch.
And hopefully not on the basis of security, but...
Yes.
Well, we'd have to give the
does not
security.
quite-
I'm not sure.
I don't have any submissions on that.
I mean, it would mean that anything that required more than instantaneous decision
Yes.
could count as an adjournment.
Yes, and that's why I have laboured this distinction between adjourning the decision and the decision itself. But there are 2 points which are elided throughout my learned friend's case. Now, the next point is, what about 2B of the order? 2B then goes on to say, any further enforcement of the award shall be adjourned pursuant to Section 1035 of the Arbitration Act, 1996. Then it says, pending determination of the Section 1033 proceedings. Now, this takes me, I'd say 1 point on this, and then I move to my second of 3 points. The 1 point on this is that whatever 2B means or says, and I've got rather a lot to say about that, it doesn't impact 2A. 2A is there in any event. 2A is a direction that there now be a determination, and it's on condition of security.
Well, there wouldn't be any enforcement of the award anyway.
Exactly.
Otherwise than pursuant to the decision of the commercial court subject to 2A.
Exactly. My Lord, exactly. So that takes me to my second point. Forgive me, I'm rushing, because there's a lot to cover in my 2 hours, but I think some of these points can be dealt with very quickly. So the second point then that leads me into, after my Lord Sumption's point, is what is the nature of this curious 2B? And the answer is it is completely, with due respect, misconceived. It is wrong. It's unnecessary, and there is no justification in section 1035 for such an order in any event. 1035 is about adjourning pending a foreign curial court.
Well, it's just not an adjournment, is your point, surely.
Yep.
It's not an adjournment because the only process of enforcement open to the English court is the process envisaged in 2A, and you don't adjourn something simply because it takes some time to get a judicial decision from the commercial court.
Yes. And indeed, the Court of Appeal is saying pending determination of the section 1033 proceedings. They're not even there pretending that this, or assuming that this is pending a curial court's decision under 1032. So just to go back to the legislative structure, 1032, just have to quickly remind myself of the subpart. Yeah, 1032F of the 1996 Act is what the adjournment can be pursuant to. And that's what they can have in mind. So they are adjourning under 1032F because they're waiting to see what might happen in terms of a curial court's determination of whether the award is binding or suspended or whatever. But the Court of Appeal hasn't done that. The Court of Appeal said it's pending determination of 1033, which simply doesn't work.
Yes, I mean, so that's the language of section 1035, isn't it?
Yes.
It's only where an application is made to a competent authority mentioned in 2.5, the curial, the foreign court. Yeah. I mean, the contrary argument would be that 2.5 actually doesn't specify that the country in which or under the law of which the arbitration award was made must be a foreign.
No, it doesn't. But if you put it all together, it must be. It doesn't make sense.
Otherwise, it would make no sense of the opening words.
So the question is, what does competent authority mean? Competent authority has got to be the court that has jurisdiction to set aside an award. That will be the court at the seat.
Well, the cross-reference to 2F makes that clear.
Yes.
Yes.
It can't be anything else. Now, of course, there is, I should just a footnote here, there's a sort of suggestion by my learned friend that perhaps the parties have agreed that England has become the competent authority because they've referred the non-fraud issues and the fraud issues to the English court. There's no agreement to that whatsoever.
It doesn't make much sense to say that recognition or enforcement of an award may be refused by the country which has just set aside the award.
Unless you're in France, but that will be for another day. Yes. So this simply doesn't work as an order. I have got some other references which to give your lordships, but I wonder if I can do this to save time by giving you the references. It's quite clear from the Court of Appeal's reasoning itself that what it had in mind here was that there would be a condition on the security condition would be on NNPC's right to advance its defence under 1033.
Yes, that's clear from 3, isn't it?
Yes.
Well, and that I think is clear from 174 onwards.
Yes.
In the principal judgment.
Exactly.
Who drew up the order? Does it come?
I'm told it may have come from the associate, so not counsel. I mean, I think we'll check on that.
Yeah. Presumably reflects the supplementary judgment, doesn't it?
Yes, indeed. But the supplementary judgment. So if I can just give you the references, in the main judgment, it's paragraphs 104 to 177 and paragraph 184.
Right, main judgment.
So the main judgment is paragraphs 174
Yeah.
to 177,
Yeah.
and then paragraph 184.
Yes,
And then in the supplementary judgment, the key paragraph is paragraph 28,
Yes.
which is critical, although I have to say it does take a couple of reads to understand it.
Well, I mean, in the main judgment, it's actually 174 and 175
Yes,
are the two critical paragraphs, isn't it?
yes. Now, but the point that's made in the supplementary judgment at paragraph 28 is that the Court of Appeal is necessarily imposing the condition with respect to the fraud issues, not the non-fraud issues. And of course that's important because the non-fraud issues at this point are the ones that were still in Nigeria. The point that the Court of Appeal is making in paragraph 28 is that it would be useless to condition the non-fraud allegations, because what would then happen is my client might not pay security. And that would mean that they would...
So useless condition, the fraud, isn't
Yes.
it? Yes, yeah.
Yeah.
Yes, well, exactly. I mean, they're saying that we want to give order security, and unless we attach it to
Fraud.
the right to defend yourself,
Exactly.
or raise these points,
For fraud.
the security won't be security.
That's it. But for fraud, that's the important point.
Rather
So-
begs the question whether there is a part of,
Yes.
or
Yes.
under the statute
Yeah.
on which they were relying. Yeah.
Can I then make the next point, same heading, and this goes to a point that my Lord Sumption's already indicated. No adjournment was needed under 1035 in any event, but just to round that point off, there is a temporary prohibition in the CPR on recognition and enforcement that comes into force once you've raised a defence, or there is a defence, under Article 5 of the New York Convention. And that is CPR 62.18, sub 9.
Where do we find that?
That's in the third authorities bundle, the new one, at tab 1. It's MS9, begins at MS 972, which is CPR 62.18, which is the provisions on enforcement of awards. And if you go over the page to MS 973, sub 9, you have the following. Within 14 days after service of the order, or if the order is to be served out of the jurisdiction, within such other period as the court may set, the defendant may apply to set aside the order, and B, the award must not be enforced until after the end of the period or any application made by the defendant within that period has been finally disposed of. So
if it's an adjournment as of right anyway.
yes. If it's helpful, that point has been picked up. The nature of this temporary prohibition was picked up in the judgment of Mr. Justice Eder in the Y versus S case. I just give you the reference for now. It's Authorities Bundle 1, tab 16, paragraph 20, where he refers to what he describes as a temporary prohibition in any event on enforcement in these circumstances.
This section of the CPR applies to
New York Convention.
foreign New York
Yes.
Convention.
Yes.
It might be helpful to look at the to see where that's made clear. But it's
Actually, well, no, I say that. Let me just quickly.
6218(1)B
Oh, yes,
refers
forgive me.
to section 101.
I'm sorry, forgive me. I didn't.
6218(1)B refers to section 101 of the 1996 Act.
Yes. But the scope of the section, going back to 6217, is for all enforcement, because everything was brought together in the CPR, both section 66, domestic enforcement, and New York Convention, into one scheme. But then that's right. There's a cross-reference. Lords, can I move to the third of the 3 points I'm making under this heading, which is then just to look at the authority on 1035. So having established that Court of Appeal order was misconceived itself, one's left with the situation where what the Court of Appeal has done is to use 1035, because they've referred to it, as a basis to impose a condition for 1033. And the question now is, can they do that? And that takes me to the authority.
Dardana.
Yes. I have to come to Dardania twice in my scheme, I'm afraid, because it's relevant also to, when I get to the next point on 1033, whether you can impose a feta or not. But at the moment, I'm just focused on how you can use or not use 1035. Dardania and UKOS is obviously the lead case. That is, if I can ask your lordships to take that up, Authorities Bundle 1, tab 6. It's MS 600. The facts I just very, very quickly summarize. An award, excuse me, an award made against UKOS in favor of Dardania, or its predecessor, in Sweden. UKOS applied in Stockholm to set aside as the seat. An ex parte application for permission to enforce under the New York Convention in England. UKOS raises its defenses under Article 5 of the New York Convention. It says there's no valid arbitration agreement. And then there is an issue as to staying that process and going back to Sweden. Actually, what happened was that Dardania had a change of heart because things were going badly in the English court. So having asked the English court, as you may remember, to decide these issues, it then decided it would be better off to go back to Sweden. So it was keen on an adjournment at that point. And the question then was, on what basis would the court impose a condition of security for the case to go back to Sweden? A condition of security was imposed. The Court of Appeal held that the nature of the order for security was illegitimate. It was inappropriate, and the discretion had been improperly exercised. There are, if I can just summarize this, there are really two strands in my submission to the reasoning in Dardania, and these two strands were not picked up properly by the Court of Appeal in the supplementary judgment. The first strand is whether the court can impose a feta on a Section 103 defense. So if you've got a defense like jurisdiction, no jurisdiction, or some other Article 5 defense, can the court feta that by way of a condition for security? That's one strand. And that points to what is the scope of Section 1035, or Article 6 of the New York Convention, which is the part of the convention addressing security. The second strand, which is separate in my submission, is when you're within 1035, what factors impact on the court's exercise of discretion? And the key issue in Dardania was who was the claimant and who was the respondent in truth. And the Court of Appeal held that the first instance judge had got that round the wrong way. Actually, it was a different party. It was Dardania that was actually applying for the adjournment, so it was wrong to impose a condition on the other party. Now, I hope that's clear the way that I've tried to describe that, because the Court of Appeal distinguished, in our case, distinguished Dardania on that second point. And this is what my learned friend does in his written case as well. He and the Court of Appeal say Dardania doesn't help in this case because that was about who is the claimant and who's the respondent, and our facts are different. In my submission, that is the second strand. The first strand is unaffected by that, and that is the question of the scope and proper use of Section 1035. Can I then turn to just the key paragraphs of the judgment? By way of context, it is a little bit complicated, but by way of context, paragraph 5 of the judgment, MS 602, sets out the procedural position and the orders that had been made. I won't read all that out now, but that sort of paints the picture as to what orders were in play. For my purposes, the key paragraphs are 27 and 29. So starting from MS 609, there's a heading, the principles governing security. Just to make good the point that I've just emphasized, this section under this subheading is the first of the two issues I've identified. And it's in these paragraphs that the Court of Appeal lay down principles about the restrictions on section 1035, what it can and can't be used for. There's then a subheading on MS 610, the judge's exercise of the discretion to order security. That is the second issue, where the Court of Appeal then looked at the exercise of discretion itself. And it's at that stage where the court then moves into a discussion really of who was the proper claimant and who was the proper respondent. So now, if you will forgive me for reading it, because it is absolutely essential, perhaps the most important point in the case. Paragraph 27, starting maybe 4 lines down. And this is my Lord Mance. In most cases, as I have said, it would be the party resisting recognition or enforcement who had already begun proceedings to set aside in the foreign state who would be seeking an adjournment of the recognition or enforcement proceedings pending resolution of the foreign application. An order for security on the application of the party seeking recognition or enforcement would be the price of the adjournment sought by the other party and would protect the party seeking recognition or enforcement during the adjournment. And here's the start where it becomes very significant for us. There is no power under section 1035 to order security except in connection with an adjournment. If no foreign application had been made to set aside the domestic proceedings under 1032, to set aside, the domestic proceedings under 1032 would have had to be fought out to a conclusion. And there would be no power under section 1035 to order security during the period which that took. There could, of course, in an appropriate case, be an application for freezing relief, as I have already mentioned. Now, can I just pause there and interject a submission? The distinction that the court is drawing here is 1035 and then a freezing order jurisdiction, which in my submission is important in this case. There are many complaints made by the other side about is security once ordered just to lapse if it's no longer 1035 and now it's 1033? But the short answer to that is 1035 has limitations which are dictated by Article 6 of the New York Convention. You can only have security under the New York Convention if you've got a proceeding in a foreign court pending. What then happens outside of that limited scope? The answer is the court has other tools available, but they're limited, primarily freezing injunctions. So if the concern is dissipation of assets, you can protect a Section 103 action with a freezing order. But what you can't do is to use 1035 beyond its permitted scope. Then paragraph 29, if I may.
Well, 28 we've got to look at, because 27, Lord Justice Mance was looking at the power under 1035.
Yes.
As you rightly point out, 1035 is dealing with a different situation from, because it's merely dealing with postponement,
yes,
from 1032, which are substantive challenges. And he considers that in paragraph 28, doesn't he?
Yes, that's right. 28, I'm not sure, takes matters further. I'm happy to read it out, but I'm...
It's the same point, isn't it?
Point.
That if you don't adjourn but determine the issues, that's a different thing from adjourning,
yes.
It's in respect of adjournment that you get security.
Yes.
I mean, the important words there are the words in brackets on about line 5, which says precisely what the consequence of non-provision of security will be.
Yes.
Failing which, the order for adjournment will be vacated and the issues determined,
exactly.
Not failing which there won't be a determination and enforcement will be made.
Exactly.
Well, that's the contrast made in the next paragraph.
In paragraph 29.
With the tacit basis.
Yes, so can I read...
Our case is not tacit but express.
Exactly. Can I read 29? My Lord Torsten, with respect, we entirely agree. That is our point as to what are the consequences of not providing the security, which rather tells you what the nature of the order is. 29, the reality in the present case, as I have said in paragraph 5, is that the appellants were obliged to provide the security on the tacit basis that if they did not do so, then enforcement would be ordered unconditionally against them, despite their outstanding application under section 103(2). The provision for security was, in other words, made a condition not of any adjournment sought by the appellants, but of avoiding immediate and final enforcement. And failing its provision, the appellant's outstanding application under section 103(2) would have been liable to be struck out or dismissed without determination of its merits. I do not consider that as a legitimate sanction to attach to any order made for the provision of security in the present circumstances. It would involve overriding or fettering an outstanding application under section 103(2) in a way for which sections 100 to 104 provide no warrant. It is inconsistent with paragraph 31(9) of the Arbitration Practice Direction and the concluding words of Mr. Justice.
Is that the same as the one you showed us in the CPR?
I think it is, yes.
Yes.
Yes, the
Yes.
predecessor.
Yeah, the predecessor
Yes.
of the CPR, yeah.
Yes, and the concluding words of Mr. Justice Steele's order, whereby the award was not to be enforced if the appellants applied, as they did, to set aside his order. Until the application was finally disposed of, it is not justified by the authority of Sole Bone, where an order was made that unless security of 5 million was provided, there be leave to enforce the award as a judgment. There, as I have pointed out, there was no application under section 103(2). So neither paragraph 31(9) nor any outstanding issue under section 103(2) stood in the way of enforcement, and the court could postpone enforcement on condition that the security ordered was put up. And then just lastly, the last few lines of paragraph 31 refer back to this point I've made about freezing orders, about 5 lines from the bottom. That does not necessarily mean that the order for security cannot be enforced in any way. The court's powers to make freezing orders and or appoint a receiver and order disclosure may enable this in an appropriate case. So there are other remedies, but they are restricted in terms of their requirements and objectives.
Is the general principle Lord Justice Menz was laying down qualified by the last words of paragraph 30 of his judgment? He talks about the provision of security is, as I've explained, by itself inappropriate in circumstances where the appellants didn't want an adjournment, because that, you say, is really an irrelevant
Yes.
tag on.
In my submission, that does not change the principle that has just been articulated. The way that that plays out in this case is that, of course, there are 2 tracks in this case, 103(2), jurisdiction defence,
You say that's
and 103(5).
that's a reference to the second
Yes,
issue.
yes, because that goes to the discretion under 103(5). If you are in 103(5), you've got to think about various factors. And what Lord Justice Mance said in this case was, and this is set out at paragraph 33.
It goes to the question who's asking for the
Yes,
for the
and
for the
that's a
indulgence.
discretion point. And what he says in 33 is it doesn't kill it, but it may well be very relevant.
Well, but he's in the section headed the principles governing security.
But in my submission, as a matter of sort of analysis, it's difficult to see why that should make any difference.
No, well, that's your point. You say, well, it's actually it's an unnecessary
Yes.
addition, and if one's looking at the matter as one of general principle.
Yes.
I think it's dealing with, firstly, it's saying that the tacit condition was inappropriate in the light of the principles. And then the second half of paragraph 30, it's actually dealing with the express provision which the judge below
Yes.
pointed out, attached. I say this without any direct recollection at all of my state of mind when I wrote it.
There's a when one talks about the fetter part of Dardania, i.e. one shouldn't easily or readily fetter an Article 5 defence or the right of access to an Article 5 defence. That does take me to a broader point, which I'm hoping I will have time to make, about the critical role of Article 5 of the New York Convention as being minimum safeguards, which is very important, of course, in construing our Act and its implementation of the Convention. Because what is happening here is that those minimum safeguards in Article 5 are being further reduced by the possibility of overlaying a requirement of security.
Yes, I mean, the New York Convention is no doubt, as most conventions, a compromise between interests.
Yes.
In the interests of speedy enforcement, doing away with double exequatur and so on, you have a framework laid out which
Yes.
applies internationally.
Yes. And just very, very quickly, just while we're on it, so Article 5 is the key component, minimum safeguards, which were replicated after 1958 in 1985 in the model law, the same grounds. Within that, there is also obviously some compromise because security is addressed as a filter, but only in Article 6, only by reference to one Article 5 ground, not the others.
Do we need to look at that? Have we got?
I'm going to come to that. I'm just conscious that the time is ticking away. So
You must move on. I think we've probably got most of the issues on the first point.
So in that case, can I very, very quickly just give you a few other references? I don't think I need to go to them. In terms of authority, I was going to take your lordships to Gator Assets, Authorities Bundle 1, tab 10. This is in a slightly different setting because this was an application for security for costs under the New York Convention. It is a judgment which, with respect, is almost impossible to understand because each of their three lordships were doing something slightly different, and hence the head note is rather long, describing each one. But the paragraphs 81 and 82 refer back to Dardania and make the same points. I'll just quickly see if I need to take your lordships there.
Well, I mean, basically, Lord Justice Ricks is saying, following the line in Dardana and saying the only context in which you get security is Article 6 or Section 103, subsection 5.
And then ConocoPhillips, I won't take you there. It's at Authorities Bundle 1, tab 4, at paragraph 52, which is Mr. Justice Popplewell. Again, without actually citing Dardania, but coming to the same conclusion about the limited scope for using 1035.
Paragraphs?
It is, forgive me,
52, was it?
52. You get the facts from paragraphs 4 to 7, but it's one paragraph, 52, which comes to the same point, or similar point.
Yes, only applicable where there's a challenge.
Yes.
Under F, yeah.
Very, very briefly before I move on to the other arguments. The points put against me by IPCO, there are about 3 of them, but none of them are of any significance in my respectful submission. The first one is the argument at paragraphs 15 to 16 and 51 of my learned friend's written case. He says there was no extant application before the Court of Appeal under section 103.3. Firstly, that's wrong. There was an application. That application is actually dated 18th of December 2008. It's in the additional volume that we have handed up.
If you stay enforcement pending an adjournment, in circumstances where there's an application either to raise the defence or to adjourn, if you then lift the adjournment, your case is that the application is there. It revives, not necessarily with the lifting of adjournment.
It was never withdrawn, never compromised.
So where do we see the application? That was going to be one of the questions I was going to ask.
Yes, so the application is the additional volume 2 at tab 1. It's dated 18th of December 2008. So that's the extra volume we handed up.
Additional volume 2.
Yes. And behind the second tab, you'll see the consent order, 17th of June 2009.
What MS? Is it got an MS?
Yeah, MS 957.
Behind the second tab.
Yeah.
Volume 2.
Yeah, it's that additional thin volume that was handed up. So the position is rather straightforward. There was an application. And in fact, it's always been recognized that there was an outstanding application under 1033. It was all then put off to Nigeria. And once the consent order was set aside, it came back to life. But in any event, this doesn't make any difference, even if you were not to be with me on that rather obvious point. Because ultimately, what the Court of Appeal has done is it has directed a 1033 trial. So that is the issue now. It's entitled to do it if it wanted to do it of its own motion. I showed your lordships that when we went through the legislative provisions. So whether or not there was an extant application, clearly there was, the Court of Appeal has ordered the trial of a 1033 issue. I don't think I need to dwell on the other IPCO points for now. None of them make any difference.
Right.
So I'm then going to move on to, well, if it's not 1035, what has happened here? There are two possibilities. One is that the order could be made somehow under 1033. We say it cannot. There is no provision in 1033 for security. The second possibility, which now is the core of Mern Friend's case, as I understand it, apart from his preliminary issue, is, well, you can just do it under CPR 3.1, which is a general case management power to add conditions.
You say this is an occupied field?
Yes. I think that's it, actually. But I'll still use my time if I may. But yes. I'll just take those in turn, because there are some points to be made under 1033, which is just a little bit more about the structure than your convention, which I'd prefaced a moment ago.
Well, yes, right, make points quickly. Yeah.
It was conceded by IPCO that there is no power under section 1033. There's no jurisdiction conferred by 1033 to order security. The reference to that is IPCO's submissions to the Court of Appeal of the 12th of October 2015, and they are at core bundle 8G. Can you give me the MS number?
I don't think concessions are going to decide the case if it's
I've got
being...
other points.
Yes. Sorry, core what was it? Core?
It's core bundle 8 sub G, and it's MS 224, paragraph 17. It's also in paragraph 52A of their written case before this court.
Right.
So now just the other points I want to flesh out before I move on to the CPR, because what I'm going to say now, if I may put it this way, is very, very important context to the occupied field point of CPR 3.1. Picking up what I prefaced a moment ago, Article 5 of the New York Convention plays a critical role in terms of minimum safeguards. It's a quid pro quo following what happened from Geneva Convention to New York Convention, as my Lord Mance has already observed. So the New York Convention brought in this mechanistic approach to recognition and enforcement, unlike the Geneva Convention. But as a quid pro quo, there were irreducible minimum standards that had to be there by way of protection. That is Article 5, essential minimum safeguards, and as I said before, replicated exactly in Articles 34 and 36 of the model law in 1985. The importance of this was set out in Dalla by Lord Collins. We've set this out in my written case at paragraph 48, where he refers to the well-known cases of Canoria Guinness, and he refers to Vandenberg. Just to make the point, Article 5 safeguards fundamental rights.
Paragraphs of the judgment are we talking about?
It is paragraph 102 of Dalla.
This is the quoted paragraph.
Yes, 584, yes. MS 584. So Article 5 safeguards fundamental rights, including the right of a party which has not agreed to arbitration to object to the jurisdiction of the tribunal. As Vandenberg puts it, in fact, the grounds for refusal of enforcement are restricted to causes which may be considered as serious defects in the arbitration and award, the invalidity of the arbitration agreement, violation of due process, award extra or ultra petita, the irregularity in the composition of the arbitral tribunal, the arbitral procedure, non-binding force of the award, setting aside of the award in the country of origin, and the violation of public policy. Canoria and Guinness May said that Section 1032 concerns matters that go to the fundamental structure, integrity, of the arbitration proceedings. Now that is, in my submission, the international context that is very important in construing the extent to which, by any other route, one can fetter access to these safeguards. Can one then require security as the price of access to protecting a fundamental right in this way? There may be some situations where that happens. For example, a time limit is imposed and is not complied with, or there's some specific procedural requirement that is followed by a sanction. But when one's talking about security as a filter, as a restriction of access to an Article 5 defence, that's addressed in the New York Convention itself. That's Article 6. It only applies to one ground in Article 5. And it's 5.1e, Section 103.2f. It's none of the others. The reason behind this this condition, the possibility of imposing a condition, was expressed in the course of the drafting of the New York Convention. I'll just give you the reference for now. It's Authorities Bundle 2, tab 24. It's an excerpt of a report of the 17th meeting of the UN Conference on International Commercial Arbitration in 1956. And if you look at pages 3 to 4, you will see a description of what became Article 6 was meant for, which was to prevent...
It was Article 5 in this draft.
Yes, it was. So to prevent an abuse of that provision by the losing party, which may have started annulment proceedings without a valid reason, purely to delay or frustrate the enforcement of the award.
This is
Pages 3 to 4. It's MS...
No, sorry, it's 878.
878 at the bottom, yeah. Now, if it was perceived that that same risk of abuse should be catered for in terms of the other Article 5 grounds, they could have done that. If they thought that maybe there would be an abuse with any of the other grounds. Of course, why not just legislate for that?
Well, the other grounds are points that can be taken in the enforcing court.
Yes, and that may be...
So the procedural
yes.
remedies of the enforcing court ought to suffice to deal with those.
Yes, except that...
with cases where you've got parallel litigation.
That may or maybe not, maybe so, but of course what we're dealing with here in the convention is the particular point in question. They have legislated on when do you impose security as a condition of access. And I don't know, there may have been reasons to say, well, it's not really needed because the court is a master of its own procedure. Don't need to, you're not waiting for another court. In any event, they have not put that filter in. So what the Court of Appeal has done here is to expand the scope of 1035, even put aside 1035, they've added to the convention by saying you can impose a condition on access to Article 5 in the same way that's catered for by Article 6 already of the New York Convention, just extend it to another ground. In Part 1 of the Arbitration Act, 1996, we have a Section 77. It allows the English court for domestic awards, English-seated awards, to impose security for setting aside applications, jurisdiction challenges, appeals on points of law. That's Section 67, 68, and 69. It does not extend to Section 66.
Doesn't extend to jurisdiction where it's raised under 66?
No.
Yeah.
Sorry, that is Section 70?
Section 77.
Do we have that?
Yes.
Subsection 7.
I'm sorry, 70 subsection 7. I mean, this is a sort of peripheral point because this is not New York Convention.
Sorry, where is it?
So Authorities Bundle 1,
Yeah.
tab 1, MS 479.
A matter of interest, this wasn't canvassed below. Is that right?
I think that's right, because all of this was dreamt up afterwards by the Court of Appeal. It was a different route that they took.
Well, however you describe it, it's essentially a new point.
It came out more pejoratively than intended, but... Sorry? Yes, I'm sorry. Forgive me, I spoke too quickly. After the main judgment of the Court of Appeal was circulated in draft, there were written submissions, and the 77 point was raised. And so it's actually at MS 217 in the core volume, there's a letter from my instructing solicitors which refers to the fact on page, it's a paragraph on that page, which says that makes the point that there is no equivalent of 77 of the Act for these purposes.
So it was what relied on by your side,
Yes.
not by the other side.
Yes. To say that if you're going to do this, you need to have an express legislative provision such as 77. But you don't have that in Part 3.
Where it's page 217.
Yeah, 217, it's sub 2, paragraph numbered sub 2 on that
I
page.
see, yes.
There's no equivalent of 77. I mean, so there are 2 points here. The first point is...
I see it, and they refer, are you going to refer us to that authority on the
Yes.
domestic power?
Yes, insofar as it's relevant. I'm not sure it is, but I'll take you to that.
I'll-
But so the 2 points that are being made here are there's no equivalent of there's no express legislative provision in the New York Convention allowing this, and there could be, but there isn't. The reason there isn't is because it would be inconsistent with the New York Convention. The second point is, even on its own terms, 77 doesn't extend to Section 66 and enforcement. The authority, insofar as it's of any assistance, we've referred to at paragraph 41(3)(b) of our written case.
Sorry, I missed your last point. Section 77.
Yes.
On its own terms does not. Can you what did you
It
say?
doesn't extend to Section 66, which is the
It's a general enforcement
yeah,
provision.
recognition
You
enforcement
say
of
that's
domestic-
deliberate because you say that it would contradict the New York Convention.
No, I have to pull back at this point. Just one moment.
I was wondering about that. Yeah.
No, Section 66 is not New York Convention.
No.
So Section 66 is recognition enforcement of English-seated
Yeah.
awards.
Yes.
And for whatever reason, the drafters of the 96 Act limited 77 to just active remedies, setting aside remedies, not passive defences.
Yeah, Section 66, you can raise the defence of lack
Yes.
of jurisdiction. Yeah.
And that's not conditioned by 77.
No, of
You can
course.
defend yourself passively. But if you want to make an active remedy, pursue an active remedy under Sections 67, jurisdiction, 68, procedural irregularity, 69, appeals on points of law, then the court has a power to impose a condition of security.
But those are all situations where you are actually applying to
Yes.
set it
Yes.
aside, not just to defeat a claim,
Exactly.
to enforce it.
So, and the distinction there is between active remedies and passive defences. For an active remedy at the seat, the court has a power under 77 to impose a condition of security. For a passive defence, it doesn't. So just going back to my Lord Hodges' point, this isn't New York Convention. It's just to make the rather perhaps peripheral point that even within the domestic regime here, the power isn't in the Act. But the more significant, analytically more significant point is that for such a power to be there at all, you need an express legislative provision, which is why 77 was put in. But there isn't an equivalent of that for the New York Convention. Why? Because it's not in the New York Convention. But New York Convention does occupy the ground because of Article 6. I hope that came over more clearly than it sounded to me.
So in a domestic arbitration, if there's a domestic award and the party against whom the award is made wants to prevent its enforcement on the grounds that he now discovers it was fraud, so he can do that under section, nothing to stop him doing that under section 66, advancing fraud as a defence to enforcement. He doesn't need to rely on
Is that right?
other sections.
Is that right? Could you advance?
Is that what you're saying?
Could you advance? You can advance a jurisdiction point under Section 66, subsection 3. When it says "may by leave of the court" in Section 66, subsection 1, does that enable you to advance other
Yes.
defences?
Yes,
It does.
it does. And the answer to that, I don't know if it's not going to be in your bundle, I don't think, but the answer to that is Section 81 of the Act. Section 81 is a saving for certain matters governed by common law.
Right.
Just very briefly, what happened in the drafting of Section 66 was that it was felt, the drafters felt unable to encapsulate exhaustively in the Act all the common law defences to recognition and enforcement. And so it was put on a broad basis with a saving for the common law. That saving for the common law is in section 81. Just to pick it up, I don't know if you have it in front of you. Can I just read out 81.1? Nothing in this part shall be construed as...
Have 81.
Do you have 81?
No,
No,
I
it's in
do,
the white book.
but my law doesn't.
All right. Would you forgive me if I just read it for now to save some time? So 81 is it's saying nothing in this part shall be construed as excluding the operation of any rule of law consistent with the provisions of this part. And then it says, in particular, not exhaustively, sub C, the refusal of recognition or enforcement of an arbitral award on grounds of public policy. So it was, again, not exhaustive, but an indication that under section 66 you can raise these points, but we're not going to set them out and codify them.
So are you saying the point which the other side would seek to make by saying the order for same didn't apply to international arbitration, the New York Convention, as applies to domestic one, rebounds on them in any event, aside from your point that actually there's no necessary comparison?
Yes.
Would you say that actually if you do the comparison,
Yes.
you find that in the case of a domestic arbitration, if the defendant wants to resist enforcement on public policy grounds, he can do so. He can do so under 81, which attaches to 66.
Yes.
And therefore the power to make him provide security under 77 is not available in those circumstances.
Yes. That was suggested by Mr. Justice Eder in the Y versus S case. I don't want to spend time going to it because, in fairness to Mr. Justice Eder, he was rushed and said so. He said that the case hadn't been listed long enough for him to consider it properly, but his first view was it would not extend, 77 would not extend to section 66, the ability to impose a condition on security. And that was the issue in that case. It was an application for security on a recognition enforcement matter. If you want that reference, it's Authorities Bundle 1, tab 16, at paragraphs 33 and 34.
I suppose it could arise if the creditor applies to enforce the judgment and seeks summary judgment,
Yes.
summary enforcement, and the defendant says, no, I've got this defence of fraud, and the court looks at it and says, well, not very sure about this.
Yes.
It would presumably then have a power, wouldn't it, to say, well...
But then under Part 24, you have an express power at that point, which is conditioned on a particular situation where the court is now taking a view on the likelihood of success and may condition, because it's expressly allowed to do that, condition your right to proceed with an order that you pay security.
Yeah.
But here we don't have any such express provision. If that, well, we don't have that. We don't have that provision. And whatever we have has got to be read consistently with the New York Convention.
But you said the New York Convention occupied the territory.
Yes. Yes.
But I mean, do you need to say that? I mean, if Article 3 says you can't do something, be more restrictive
Yes.
Under the convention than you can domestically, then the point you've just made, you would say, blows out Article
Yes.
3.
Yes.
Yes.
I think.
What is your separate point? That
the
territory is occupied.
All right. So the key point on territory being occupied is simply Article 6 of the New York Convention, which is that is the article where the drafters of the New York Convention have applied their minds as to when a court can impose security as a fetter on the right of access to a defence. And it's only by reference to one Article 5 ground.
But then you have to face, as the respondents say, Article 3.
Yes, so that then takes me, and that's the last point, I'm running out of time, but before I get to the discretion points, that is the last element, which is, does Article 3 of the New York Convention change anything?
And you say, for the reasons you've articulated,
Yes.
It doesn't.
It doesn't, but I have a little bit more to say on that.
Okay.
Without in any way encouraging you to be any longer than you need to be, why are you running out of time? You've indented for 2 hours, haven't you?
I was down for 2 hours, so I have 6 minutes to cover quite a lot.
I see. Well, wait a minute, we started at 10.
Oh, sorry, 36. I'm sorry. In fact, that's
well,
36.
right,
36
well,
is even
But it can
short
be
than
done
what I
in
had to
6
cover.
minutes.
I've now whetted the appetite of the court. It needs to be even
Very dangerous
faster and more.
Yes.
All right, so I feel like I've just had a moment of liberation. Thank you. In that case, I'm going to linger just for a little bit longer on this point of the importance of maintaining consistency with the New York Convention. We have put in our written case fairly obvious authorities about the fact that the English Act and also the CPR has to be construed in line with the underlying convention, which is being given effect to. That is in paragraph 43.
Well, I think the other side rely on the convention, Article 3, which is not. So I don't think they really take issue with this, do they?
Well, yes. Well, it's the precursor to the next point, which is the New York Convention a complete code?
Yeah. Right.
And the answer is yes, it is a complete code, insofar as it legislates on particular areas. And if there are gaps, there are gaps. But otherwise, you can't tread on what is already set out as in the convention itself.
But it's got to be a complete code in relation to what it covers, because otherwise it can't apply consistently internationally.
I'm sorry, I didn't catch the first.
It's got to be a complete code in respect of the issues it covers, because otherwise it cannot be applied on a uniform basis internationally, which is the presumption that one makes about international conventions.
Yes, indeed, and that is precisely the point that is made by Dicey and Morris in the reference I've got at paragraph 44 of my written case. This is at Authority 2, tab 27, paragraph 16.137, which talks about the grounds which have been closely followed in the provisions of the model law operate as a code, and their consistent interpretation and application across more than 140, which you can now read 156, contracting states is therefore of the greatest possible importance for the successful operation of the modern system of international commercial arbitration.
How many are there now? 156?
156 now.
That's your footnote 9.
There are mentions here in the authority of a complete code, and this takes me back to Gator Assets, which I've set out paragraph 51, footnote 11 of my written case, which is on page 12. It's Authorities Bundle 1, tab 10.
Paragraph?
82. So this is in a slightly different context. It's on security for costs. Lord Justice Ricks says here, it is my opinion that the structure of the convention as a whole, reflected in the 1996 Act, makes it unlikely that the framers of the convention or of the Act conceived that a form of security not mentioned in these circumstances in either, contrast the express provisions relating to security for costs in Section 76 of the Act, could be imposed on the party seeking enforcement. Whether this is put as a matter of jurisdiction on the ground that the Convention and the 1996 Act are a complete code relating to all aspects of security, or as an indication of how, as a matter of principle, the question of security for costs should be considered, may not matter. One other reference, just to make on this point of complete code, is a comparative reference. We've done a search on various databases to see if any other court has come across an issue such as this. And the one that we have managed to pull up comes from the Southern District of New York, US District Court. So for good measure, we've put that in the additional authorities bundle 3, a case called Thai Lao Lignite and the Lao People's Democratic Republic. It's at tab 4 of the additional bundle, starts at MS 982.
This is a New York Convention case, is it?
Yes. District Judge Wood and the summary of what was happening here is on page 1. On August 5th, 2011, this court entered a judgment against the government of the Lao People's Democratic Republic. After that judgment had been entered, just moving down 4 lines, on December 27th, the Malaysian High Court vacated the arbitral award underlying the court judgment. In light of that ruling, respondent moves to vacate the court's judgment, enforcing the arbitral award pursuant to the Federal Rule of Civil Procedure and Article 5.1e of the United Nations Convention on Recognition and Enforcement. And then just a few lines down, petitioners urge the court to require respondent to post security as a condition of moving under Rule 60B or as a condition for the entry of any order vacating the judgment. That was then denied by the court, and the relevant portion is at the end of the judgment, beginning at MS 1004. There's a heading B, requiring respondent to post security is contrary to the New York Convention.
Sorry,
MS 1004.
Bottom of.
So MS 1004.
Thanks.
There's the heading B, requiring respondent to post security is contrary to the New York Convention. And the relevant portion, there's a discussion, first of all, about how the New York Convention sits with the Foreign Sovereign State Immunity Act. But over the page, the last 4 lines of the judgment, 5 lines, MS 1005, in this case, respondent has already obtained a judgment setting aside the arbitral award by a court of competent jurisdiction and now invokes Article 5.1e of the New York Convention. Article 6 is therefore inapplicable to this case. Article 5 does not explicitly grant a court discretion to require security, and the court will not read such authority into Article 5.
What does FSIA stand for?
Foreign State Immunity Act.
Right. Okay.
Sorry, Sovereign Immunity Act.
That's the act, is it, which incorporates the... What's that got to do with it?
No, I think there was, because the respondent is a state, there was an argument as to how that meshed with the New York Convention and which of the 2 acts took precedence.
I see.
Have you included the
I see.
Court of Appeal's judgment that he cites, International Insurance Company and Caja Nacional?
No, but we can certainly dig that up.
That's a 7th Circuit decision.
Yeah. And I think that may be on this other prior issue as to the way in which the New York Convention in America sits with the Foreign Sovereign Immunity Act.
Right, okay. Well, if it's not relevant, don't trouble us with it.
All right, so I'm helpfully, my learned friend has said they've read it and thinks it's not relevant.
Thank you.
Thank you. My Lords, that concludes my argument on the 1033 point. It now takes me, with that background that I've given the court of this being an occupied field, to then consider how CPR 3.1 sits with this and Article 3 of the New York Convention.
Right.
In my respectful submission, the structure which exists in the New York Convention and the principles which have been set out by the English courts, notably in Dardania, are not swept aside by CPR Rule 3.1. The first point I want to make before elaborating on that submission is that it is by no means clear in this case that the Court of Appeal was actually exercising a power, thought it was exercising a power under 3.1 of the CPR. It does not look as if that's what the Court of Appeal thought it was doing. It looks as if the Court of Appeal thought that the power came from 1035.
I mean, was there any reference to CPR 3.1?
No.
By either side?
No.
Yeah. Well, then, and there's no reference in the judgment.
There is, but I just wanted to show you where that reference is.
Oh, so with the what? Yes, I remember, yes.
So neither party relied upon CPR 3.1. It's not.
What did the judge say about? What did Lord Justice Clark say about that?
Well, there's no mention of it at all in the main judgment. So the main judgment comes to the conclusion that the condition will be imposed. The only basis that one can think of is 1035. Then, if one then turns up the supplementary, which is where the reference comes, the supplementary appeal judgment, so that's in the core volume under tab C. It's not mentioned anywhere in the discussion section of the supplemental judgment. The discussion section begins at MS 171. And there, it looks like it's 1035 that is again still motivating the court.
Well, the order says it's one.
The order doesn't make any reference to 3.1. Exactly. The order to be in terms is relying upon 1035.
So where's the reference?
So the reference, can you just remind me of that?
CPR?
Yes, the reference, there's a passing reference in paragraph 6, which is really the only reference to 3.13a. But the issue here is a different issue that they're talking about, actually. And this seems to be conceded by my learned friend in his written case. If I can just point you to IPCO's case, paragraph 30. So first of all, just looking at paragraph 6. The point that's being made here is about the court acting of its own motion. So in Dardania, Lord Justice Mance, as he then was, was fully prepared to proceed on the basis that 1035 provides the court with jurisdiction to make such an order in a case where it, either of its own motion or at the instance of the party. So that's the point that the Court of Appeal is making here. And then it goes on to say, it is not wholly clear to us how Section 1035 was thought to provide jurisdiction to the court to act of its own motion, but in any event, a court which is asked to adjourn or continue an adjournment of enforcement is entitled to impose conditions on the exercise of its discretion to do so. And then there's a reference to CPR 3.13a, and may do so of its own initiative, 3.3. But that's the only reference. It doesn't appear in the Court of Appeal order. In paragraph 30 of my learned friend's written case, it stated, it seems to be understood by both sides, that this was a reference in a different context. But they say, well, that doesn't matter. So it's by no means clear that this is what actually they thought they would do. But if I now proceed on the assumption that they were exercising a power under 3.1, there are 3 points I need to address. Firstly, the proper construction of 3.1 itself, and by reference to all the materials that I have already shown the court. It's my first short point. I think I've already made it, actually. But the first short point is, given Dardania, given the principles already established by the Court of Appeal, given the structure of the New York Convention, Article 3.1 has got to be read subject to those principles. Can't just sweep them away. Otherwise, if my learned friend is correct on this, 3.1 of the CPR would have been an answer to Dardania. I mean, the short answer to Dardania is, well, the court will just impose a condition, if it wants to, on any basis under 3.1, because it can.
But 3.1 is simply saying what the court's powers are.
So, forgive me, I'm abbreviating this. 3.13a.
Yes, but the whole of this section of the CPR is simply saying what the court's powers are, whether the court has jurisdiction to exercise those powers in any particular case is the next question.
Yes.
And whether it should do so as a matter of discretion is the question after that.
Yes.
But all that is doing is saying, in a case where it's got jurisdiction, these are powers it can exercise.
Yes. Now, so, my lord, if I then put this, I can put this either under that structure as a jurisdiction point, or I can put it as a discretion point. 3.1 can't sweep away, for example, Dardania. If Dardania says that you can't fetter access to an Article 5 defence with security outside of Article 6 of the New York Convention, well, that's the answer to 3.1 as well. The same could be said for Gator assets. The same can be said for ConocoPhillips. All of these cases would be a rather short judgment, if my learned friend's correct, which is, well, the court can do what it wants, discretion or jurisdiction. And in my respectful submission, that cannot be right. The second of my 3 points.
This is the first time that point has been expressly taken, is that right?
In this case, or anywhere.
In any of the cases? I mean, the
Yes,
CPR point.
yes, to my knowledge, which is an unsafe point to proceed on, 3.1 has never been argued as a basis for imposing a condition of security in the context of your convention. No. But on the contrary, we have this whole line of cases that I've taken you through already setting out what the principles are. So the second point I need to address is Article 3 of the New York Convention. My learned friend's major point here is, well, the court is allowed to get to Article 3.1, Rule 3.1 of the CPR, through the window of Article 3 of the New York Convention. Can I just take you back to Article 3 of the New York Convention? It's in the authorities...
Is there are you going to come to the question of interpretation of the power under
Yes.
3.13? Because,
Yes.
I mean, conditions are usually introduced as the price of something. And how does... I'm not sure how one applies that
Yes.
here.
Well, one has to do it through the Vienna Convention on the law of treaties to interpret Article 3.
Sorry, I meant I was talking about CPR. Anyway, go on.
Oh, I'm sorry.
I'll come back to the point.
The editorial note to at 3.1.4 suggests that there's quite an amount of appellate authority on the scope and effect of
3.1.
3.1.
Yes, I'm coming to that.
Right.
Can I just outline the points I'm going to make? So the first one I've made is the first point I've made is simply consistency with all the Dardania authority and the New York Convention that I've gone through.
Right. Yes.
The second point is, what is the interpretation of Article 3 of the New York Convention? The third point is, what is the authority on 3.13a itself? And that, in particular, takes me to Court of Appeal authority. One case I'll show your lordships, if I may.
Yep.
So those are the points. So now on the second point, just to turn up, and now I'm just looking at Article 3 of the Convention before I come back to the CPR. Article 3 of the Convention, it's in Volume 2 of the authorities at tab 22, MS 868. I read this before, but forgive me just to read it again. Each contracting state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon, under the conditions laid down in the following articles. So there are two concepts there, rules of procedure and conditions. The obligation through the local rules of procedure, the obligation is to recognize and enforce under the conditions that are laid down in the Act. Laid down in the Convention. And those conditions are in Articles 4, 5, and 6 of the New York Convention. So what you can't do through the rules of procedure is change the conditions of the Convention, because they're set out. There may be scope to add if there are gaps, and that there is scope to add time limits and things like that. But where the field is occupied by Article 4, 5, and 6, those are the conditions. You can't add or detract from those. This is the understanding of the leading commentators on the New York Convention. Can I just take you to some of those very briefly on this point? Vandenberg, who is one of the leading, obviously, world authorities on the New York Convention, second volume of authorities, tab 26, starting at MS 893. There's a heading, Rules of Procedure for Enforcement of Convention Award. Can I just turn forward to MS 896 and 897? Vandenberg says here, it should be, this is internal page 239, it should be emphasized that the rules of procedure of the Forum for the Enforcement of a Convention Award, as mentioned in Article 3, are not concerned with the conditions for enforcement. The rules of procedure within the meaning of Article 3 are confined to questions such as the form of the request and the competent authority. The conditions for enforcement, on the other hand, are those set out in the Convention and are exclusively governed by the latter. This is unequivocally stated in Article 3 in the phrase, under the conditions laid down in the following articles. It means that the procedural law governing the enforcement of convention awards may not derogate from the principles embodied by Articles 4 to 6. Just pausing there, that really is all I really need to say actually on this in terms of the commentary. It's exactly the point. Insofar as the field is occupied by Articles 4 to 6, that is the end of the story. It may be that there are other areas that are not occupied by 4, 5, and 6. So be it. Then rules of procedure can add. And some of those rules of procedure may add conditions even at that point, but which may have an impact on access to Article 5, time limits, for example. But it's no-go if it's already covered by the Convention.
Well, I suppose if someone defaulted in discovery,
yes.
you could order them to
yes.
put up part of the award if
exactly.
you were in an extreme case.
Exactly.
Yeah.
The final paragraph on the page is quite helpful
yes.
in elucidating his interpretation of it and identifying the word conditions bears a somewhat different meaning in the two sentences
yes.
in Article 3.
Yes, I mean, it's well known, not the only bit of the New York Convention, it's well known that Article 3 is badly drafted. So commentators frequently make the point that actually the second sentence of Article 3 seems to be using conditions in a slightly different way. It doesn't impact on the point before your lordships now.
Yes.
Just to round this off, over the page, MS 897, Article 3, the first full paragraph there, Article 3 can also be considered as the basis for the application of the law of procedure of the Forum to those aspects incidental to the enforcement which are not regulated by the Convention, which Professor Vandenberg has emphasized.
An attachment, I see, they're freezing orders is otherwise one example.
Yeah, exactly. And again...
Others are discovery.
Yes, others are discovery. So, of course, there will be rules of procedure through Article 3 which may impact on your right of access to Article 5. But, and I can't pretend now to delimit exactly the scope of Article 3, but what I can say is it's defined, that outer limit is defined by what is covered expressly in the Convention. And that's all I need to say.
So does anybody express a different view?
No.
Give the context.
No. The other references, this is, Vandenberg is a book that, like Mustel and Boyd, has been crying out for another edition for a long time, but we get a more recent statement, similar statement, happens to have been written by Professor Vandenberg very recently in the IPCO Guide to Implementation of the New York Convention. That is in the extra bundle of authorities that I've handed up, and that is in, it's at tab 6, MS 1012. So I'm not pretending this is, well, this is actually, I'll withdraw it. This is a statement of the international consensus much more recently. ICA, the International Council for Commercial Arbitration, as you may know, is one of the leading international bodies with responsibility or an interest in arbitration. It brings together leading figures from around the world, and this is their handbook for judges.
It's written by Vandenberg?
Yes, it is. I mean, one of the key authors is Vandenberg, and you'll see that the wording is almost identical here. This is MS 1016, and the second full paragraph, the rules of procedure referred to in the New York Convention are limited to questions such as the form of the request and the competent authority for which the New York Convention defers to national law. The conditions for the enforcement, however, are those set out in the New York Convention itself and are exclusively governed by the New York Convention, i.e. the petitioner The party seeking recognition or enforcement only needs to submit an original copy of the arbitration agreement, an arbitral award, possibly a translation thereof, and the respondent can only rely on the exhaustive grounds listed in the New York Convention, etc. It's the same point in an abbreviated fashion. We've added in also again, we did well, let me just say there's, Gary Bourne is the same points he makes in his authoritative treatise. That's at tab 5 of the third volume of authorities. Starts at MS 1007. If I can take your lordships to 2710, internal 2710, which is MS 1010. It's the last paragraph on that page. Although badly drafted, it is apparent that the reference to conditions in the second sentence of Article 3 is to the procedural rules and conditions relating to the recognition of an award. It is not a reference to the substantive exceptions referred to in Article 5 regarding the existence, validity, and scope of the arbitration agreement, the conduct of the arbitration proceedings, and the like. Rather, Article 3 is concerned only with purely procedural aspects of the recognition proceedings themselves, e.g. filing fees, time periods, judicial access. Accordingly, Article 3 cannot be relied upon as a basis for applying national law to substantive issues concerning recognition of an award, which are instead addressed solely in Articles 4 and 5 of the Convention. And in my submission, that must extend to Article 6, because Article 6 is qualifying Article 5 of the New York Convention.
And this is really concerned with substantive rules, isn't it, about enforceability?
Well, I mean, it's difficult in a sense to draw the line in Article 3 between procedural and substantive. Some procedural issues will have a substantive impact.
Well, security for an adjournment, if that's what we're talking about, would unquestionably be procedural, wouldn't it?
Yes, but I think that
that's perfectly consistent with it being a burden, and you would say an unwarranted burden.
Yes.
On enforcement,
Yes.
but it's procedural.
Yes, and which is why I come back to, I think, the simplest answer to this, rather than making distinctions for Article 3, procedural or substantive, it's in its precise content, it's easier simply to conclude the outer limit of Article 3 is whatever is actually covered expressly in the treaty, in Articles 4, 5, and 6. We've also put in a decision of the Italian Supreme Court, which is at tab 3 of the additional bundle. And the relevant paragraphs there, MS 978, are paragraphs 5 and 6, which also talk about the limits of Article 3. So it's just the bottom of the page at 978, paragraphs 5 and 6. Just a few other points on this before I round it off. I can make the same points, I think one should make the same points, about the internal consistency between Article 3 and the other articles of the New York Convention in the language of the Vienna Convention on the law of treaties, because the New York Convention obviously must be interpreted and construed in accordance with the Vienna Convention. We've added in the Vienna Convention Article 31, for good measure. That's at tab 2 of the additional authorities bundle, starts at MS 974. Article 31 of the Vienna Convention mandates this court to take into account, when construing Article 3 of the Convention, context. Context.
Sorry, which article's that?
So Article 31 of the Vienna Convention.
Sub 1.
Sub 1, yes. So I mean, I'm taking this very quickly because it's very, very familiar ground. But
Familiar stuff.
yes. So 31 is the customary, a statement of the customary international law rule of interpretation of treaties. One of the elements is context when you are working out the meaning of words in a treaty. And at tab 8 of this binder, the additional binder from MS 1024, we've added an excerpt from Richard Gardner's book on treaty interpretation, which talks about the meaning of context in the Vienna Convention.
What is the context we're looking at here then?
We're looking at, so the context for Article 3 is Articles 5 and 6.
I see. Well,
Yeah, it's the same point, but just I'm giving you the terminology.
part of the context is part of the treaty, but
that's what context means. As a matter of international law way of looking at it is to say context under 31 of the treaty is the other provisions surrounding the particular provision you're interpreting.
The linguistic context.
Yes.
Yes.
And also, I think I need to move straight on to I've got the last element of my three, which is what about, so that's Article 3 of the New York Convention. The next question is, even if I'm wrong on that, very quickly, 3.1 itself, of the CPR, 3.13a, according to Court of Appeal authority, would it give the court a jurisdiction here, or power, or discretion here, to do what the Court of Appeal has done? This is my Lord Toulson's question. And the key authority here is Huscroft and P&O Ferries, which is in Authorities Bundle 1 at tab 12. There are many other cases that are cited in the commentary in the White Book, but in my submission, it takes it further than the statement we have in this case. This is starting at MS 745. The principles, which are articulated by Lord Justice Moore-Bick, are at paragraphs 17, 18, and 19. So MS 750, 751 to 752. Picking up from paragraph 17 at letter G, about 5 lines down. In particular, Rule 3.1 sub 3 is deliberately drafted in quite general terms. I think that this court should be reluctant to lay down any hard and fast rules about the circumstances or manner in which the power can be exercised. Experience shows that cases are infinitely variable, and the rule does not place any limit on the nature of the conditions that may be imposed or the circumstances in which the power may be invoked, other than providing that a condition may be imposed as an adjunct to an order. However, 2 matters seem to me to provide support for the view that the power to attach conditions to an order is intended, as Mr. Meyerson submitted, to enable the court to exercise a degree of control over the future conduct of the litigation. And then he goes through reasons for that. So just pausing there, the key point he's making is this is case management, and it's about the future conduct of the litigation, not necessarily past behavior. 18, paragraph 18. Having said that, I think it is also necessary to recognize that Rule 3.1 sub 3 does not give the court a general power to impose conditions on one or other party whenever it happens to be making an order. And if District Judge Babington thought that it did, he was, in my view, wrong. When the rule speaks about the courts making an order, it is referring to a direction that a party act in a certain way, and that a certain state of affairs should exist, not to the instrument used to give effect to one or more such directions. The court has ample powers under Rules 3.12m, 3.3 to make whatever orders are needed for the proper management of the proceedings. The purpose of 3.13 is to enable the court to grant relief on terms, and when the power is exercised, the condition ought properly to be expressed as part of the order granting the specific relief to which it relates. I won't carry on reading for now, but just to drop down to paragraph 19 at the bottom of the page, 3 lines from the bottom. I do think, however, that before exercising the power given by Rule 3.13, the court should identify the purpose of imposing a condition and satisfy itself that the condition it has in mind represents a proportionate and effective means of achieving that purpose, having regard to the order to which it is to be attached.
I'm surprised you passed over what's at letter D on 751.
Yeah.
Where it says paragraph 1 was framed as a freestanding order.
Yes.
Such will pay as security. These rules of a kind one might expect to see following an application of security under Part 25, not under the general sweep-up power.
Yes, I haven't read it out simply because of time.
No, but the basic point there being made is that the freestanding order is not really what this is about. It's a condition or price of
for a specific procedural
Procedural
order.
indulgence.
Yes, yes. So what is the procedural indulgence here? There's, going back to where I started, may feel like a long time ago, there's no blame that the Court of Appeal has attached to any party here. There's no finding that we were responsible for what's happened in Nigeria. Equally, there's no finding that IPCO was responsible. There's no finding that we have delayed in the English court. There couldn't be. There hasn't been any delay in the English court. What's happened is we're into the commercial court case managing now a fraud trial that's listed for next January. There's nothing we can do to slow down that or speed it up. What is the purpose here? Now, coming back to, and the answer to that, my rhetorical question is, the purpose is simply security as an end in itself.
There seemed to be some suggestion in the Court of Appeal that it was to
goad
people or,
yes.
or to give them a prod. But
that, in my respectful submission, is unsustainable on the facts of this case, because you've got to distinguish between Nigeria and England.
Well, the evidence is that in Nigeria, there's nothing you can do about it.
Yes.
And in England, it's been done.
It's been done. And there was no criticism of us in England. So the goad is not, if I may say with respect, is simply not good enough as a justification for 3.1 here. There isn't any order to which this can attach, actually, this condition. There would have to be some findings that we have acted in a dilatory fashion or recalcitrance, etc. So, and again, it takes me back to the range of options that this court has. This court, if it wants to, can order a freezing injunction, but then there's got to be evidence of dissipation, and there isn't here. The court could impose a sanction or a condition if we have misbehaved in the conduct of the English litigation under 3.1, but we haven't.
Well, I mean, because of the point which you stressed at the outset, that the courts below had simply said there's a bona fide defence here, we're not concerned with a situation which might arise where the defendant seeks to resist on the ground of some fraud. The basis of it appears pretty tenuous. The applicant seeks an immediate enforcement order. Court says, well, I'm not sure it will necessarily be just to make an immediate order. On the other hand, we're deeply suspicious about
yes.
the whole thing. Now, that's a situation with which we're not presently concerned, but at the moment, I'm not sure that the court could not, in that situation, say, well, rather than we won't grant immediate enforcement, but we're going to protect the position.
Yes.
Because there's all the signs that this is merely stringing out
yes.
a genuine liability.
if it's possible to conceive of a summary application for enforcement, that's the scenario
yes.
when that would arise.
There are two may I suggest
I
two
think you
situations.
must watch out for the time.
All right, I may have to just ask for just a very slight indulgence, just to quickly go through points on discretion, but only with
Well,
very,
how
very high
long?
speed.
You're cutting into your reply
Yes.
time, potentially.
Yes.
Are they made in your case?
Sorry?
Are they made?
No, well, just before, can I just answer the question that's there, my Lord Toulson's question? There are two scenarios here. The scenario my Lord's put to me is sole bone, primarily. That's catered for in section 1035 and article 6 of the New York Convention. If you think that somebody has got, so you want to adjourn because somebody wants to bring some case, and you think it's a flimsy case, that's sole bone, and you're restricted to the conditions in article 6 of the Convention. And so you can't go beyond that. And that's an answer to that. If you're not in sole bone, then you can't do it unless there's a specific situation, for example, as my Lord Mance has suggested, a summary process and some condition attached, and that's some other express provision. But again, that doesn't apply here. Then can I quickly outline 5 points on discretion? And I'm into injury time. If I'm wrong on all of the above, did the court actually then, was it corrected as point in a matter of principle? Did it take into account the right factors in the exercise of its discretion? Point number 1, we are in the position of defendant. We are not claimant. We're in a position, we're a defendant with a good, arguable, prima facie case with a defense. You do not ordinarily condition the access of a defendant to a defense, to the ability to defend itself. And this we have set out in our written case. You wouldn't do it with security for costs. Settled practice. And so why would you do it for the actual substantive defense? My learned friend puts to me, this is my written case, paragraph 69 to 70.
You wouldn't do it on a summary judgment application.
No. I mean, it's basic justice. We have got a defence, which the Court of Appeal thinks is a recognisable defence.
Yes, well, I think we've got the point.
Right. Next point. The one addition I wanted to say is that there is an argument put on the basis of Lord Justice Ricks's comment in Gator Assets that we actually should be thought of not as respondent but as claimant. And that, in my respectful submission, is wrong. We are answering a claim. We are defendant. And if I need to, I'll take you to Lord Justice Buxton's analysis in Gator Assets.
Well, you're answering an application to enforce an award that has been made against you, which may not put you exactly on a par with the defendant, but we have your point.
But the very short point is awards are not judgments. They're not self-executing. You have an award, as my Lord Mance said in Dalla, with a tennis analogy. You may
The traditional way was to sue on the award,
Exactly.
and you could raise these by way of defence, and it's the
Yes.
statutory process.
Yes, and the common law action on an award, the nature of that has not changed by the summary process. The summary process was brought into English law in order to facilitate procedurally the common law exercise.
Well, it's a registration process like...
Yes, but no, it's not. It's registration and a summary process to allow you to do what you would do at common law. At common law, you are claimant, seeking to enforce your award, and you are respondent, raising defences to that. That's not different because the process has changed. Second point is, I'll just refer to paragraphs 72 to 73 of my written case. These are the points under the European Convention on Human Rights, Article 6. The only point we make here is that if you are going to restrict the right of access to court, it's got to be to pursue a legitimate aim and be reasonably proportionate, and it isn't here. $100 million in the context of this case. We're not saying that you can never do it, this part of the argument, contrary to what my learned friend is characterising my case as being, but here there's no basis for it.
Right.
The next point is that if you are against me on all of this, and if you say that CPR 3.1 does give the court power, then in my respectful submission, the factors that should have been relevant to it should be those factors as in 70 sub 7 of the 1996 Act. And for that, the authority is the case A versus B. My authorities bundle number 1, tab 3. You would then have to show that the challenge is flimsy or that there would be a risk of prejudicing enforcement by allowing the challenge to proceed.
That's the is that the only authority under Section 70, subsection 7?
There's also Y and S. A versus B and Y and S give you the test.
Right, that's the test.
That's the test. So that's how it should be. The fourth point is that the practical effect in this case of this kind of condition is unfair, and it's not what was intended by the New York Convention. The practical effect is that simply because the Court of Appeal thought that it would be the right thing to do without any particular reasoning, 2 Nigerian parties who have got an award rendered in Nigeria come to England, and for one of those parties to defend itself in England, they have to bring into the jurisdiction all the assets, which is a very peculiar result. In particular, as this court may know, under the authority of Mr. Justice Steyn, as he then was in Rosseel, the English courts can hear a recognition and enforcement application under the New York Convention, even if there are no assets in this country. There's no jurisdictional requirement for there to be assets here in order to come here with a New York Convention application. So the result of all this is wonderful forum shopping. Anybody comes to England. There's no connection with England at all. You come to England, and then you take the benefit of this principle, and you force the other party to bring all the assets into England. And that is a very peculiar result. I'd say in my submission, not what the Convention contemplated. And the last point of all, before I finally sit down, is that this case is different from others because it is a case where we are proceeding on the basis of a good prima facie case. Not only that, but of fraud. And so actually what the result of the condition here is, the way that it's been crafted by the Court of Appeal, is that if we don't put up the money, $100 million US, there will be recognition and enforcement without hearing a good prima facie case of fraud. And so an award which on a good prima facie basis may be contrary to English public policy is enforced. I apologize for exceeding my time, but unless I can be of any
Yeah, thank you very much indeed.
For assistance, those are my submissions.
Mr. Willan. Mr. Black.
My Lord, I will follow, if I may, the same structure as my learned friend. But before I do that, may I make a prefatory remark which permeates everything I'm about to say and indeed also highlights what I say is a fundamental flaw in my learned friend's legal submission. He said in answer to my Lord Clark that this was contrary to a whole line of cases, that there were no cases in which CPR Rule 3 had been considered. All of the cases that we have looked at involve cases where, for example, security for costs are being sought against an award creditor. And so each of the cases that has been cited to this court today really is through the lens of Article 3 of the New York Convention, which says that you can't put more onerous conditions upon the enforcement of an award than in the convention, in the local procedures. The convention is silent as to what conditions can be applied to the challenge to an award. There is nothing said anywhere in any of the provisions, articles of the convention, save for Article 6, which is not dealing with a challenge in the enforcing court, but it is dealing with adjournment pending the challenge in the curial court, which, as we'll see, Professor Vandenberg said was necessary because it would be a new provision in many civil procedure codes in different jurisdictions. And so it's important to bear in mind, we say, that when one looks at the authorities, one realizes which way, if you like, the condition is going. And each of the cases has, when there has been resistance to an order for security, for example, is when it's been sought against the award creditor. It is true that my learned friend finally found the case at the end of the day that they put in their additional authorities, the New York case from the Southern District. And we say in relation to that, that does no more than affirm, which we have accepted throughout, that Article 5 does not refer to security, but Article 5 is all about challenges to the award subject to Article 3, and the substantive challenges to the award, but is subject, as we'll see from Vandenberg, to the local procedural rules governing the right to challenge. And indeed, also in one of the late authorities of my learned friend, again, Professor Vandenberg's statement in the IPCO Guide to the Judges, one will see that it's accepted that even more stringent conditions can be placed upon the right to challenge an award. And so it's important, as I say, to bear in mind when one looks at the authorities that the restriction is on the onerous provisions attached to enforcement. The second part of the prefatory point touches upon my learned friend's final submission on discretion. And indeed, NNPC seeks to cast itself as a defendant defending itself against a claim. We say it is not. It's an award debtor challenging the award. If the analogy with claimants or defendants is to have any meaning in this context at all, we say NNPC is more properly to be regarded as a claimant. In fact, the closer analogy...
Wait a minute. The New York Convention gives a lot of advantages, and there is a presumption that something that looks like an award is an award, but it doesn't actually say that it is an award. The balance is that you start off 15 love up, but you have to realize that the other side has a chance to continue the battle, and Article
5 are the terms which can be raised, and if they succeed, then there never was any liability, and you will have been right all along in saying that there never was. So I don't think you can start from a presumption, can you, that, or you can't start from a statement that there is a liability. There is simply a presumption at the very outset.
There is a presumption at the outset, but the important thing about the New York Convention is where the burden of proof lies.
It is a burden of proof matter.
Yes, the burden of proof lies upon the person resisting enforcement to prove the challenges under Article 5.
Yes. That's often the case with defences, isn't it? And that doesn't turn them into a claimant.
Well, my lord, I was going to go on to say...
The same applies domestically. I mean, if you have domestically, the position appears to be that if you have something that looks like an award,
yes.
Then the onus shifts to the defendant to raise the defences.
Well, my lord, that's precisely where I was going to go next, which is the closest analogy is to the appellant under Section 68 of the Act.
I think we looked at Section 66 a moment ago. And
yes.
Section 66 would enable you to raise common law defences, including no arbitration at all, no arbitration agreement, and public policy fraud as a defence.
Yes, but those defences can be lost. If you start off with a position, first of all, you have an award, and it is then, the onus is then, and let's assume that we're talking about public policy and fraud. The onus is then upon the award, the award debtor who might appeal that award under Section 68. And if he doesn't raise it under Section 68, he loses that right, because that's subject to section. If we have a look at Authority Bundle 1, look at the structure of the Act. So if the court be kind enough at MS page 476 in Authorities Bundle 1. So first of all, we have an award. There is then a right to challenge the award for serious irregularity, and 68(2)G shows that the award can be challenged on the ground that it was obtained by fraud, or the award or the way in which it was procured being contrary to public policy. We then go to the conditions under which that challenge can be made, which will be under at Section 70, MS page 479. And that application at 73 must be brought within 28 days of the date of the award, or if there's been an arbitral process of appeal, of the date when the applicant or appellant was notified of the result of that process. And so, unless we're postulating a case where the evidence of the alleged fraud has arisen after the time for appealing has arisen, then, in fact, what would normally happen would be that there would be a challenge under Section 68, which would then be subject to 70 subsection 7, which gives a power to the court to order that money payable under the award should be brought into court or otherwise secured pending determination of the application or appeal.
But you, as you say, you might not have an application under Section 68, in which case you could resist enforcement, couldn't you, in a number of the cases under Section 66, not in all. I mean, one of the points about Article 5 of the New York Convention is that it embraces all sorts of matters, but some of them, lack of an agreement, lack of a valid arbitration award, matter not capable of settlement by arbitration, public policy, all those could be run under Section 66 by way of defence.
Well, my Lord, in fact, we don't have the authority before the court because it was not a point, I think, that came out of the written cases, but is referred to in the Gator case, where it is said that if there is to be a challenge for fraud, then it's to be brought by a separate action. But that brings me to the second element of this.
You say we don't have that?
I can show you where it's referred to in Gator, and we can try and we can get the authority perhaps over the short adjournment. But I'd like to take you to Gator because it's another element of this prefatory remark as to whether or not NMPC is more properly regarded as an appellant or applicant than to cast itself as a defendant. Gator is at tab 10 in the authorities bundle, and it begins at MS page 707. The facts of Gator are really quite conventional. There was an award obtained in Russia. It was challenged unsuccessfully in Russia. The award creditor then went into liquidation, and the award was assigned to Gator. Gator obtained an order from the English court under Section 101 to enforce the award. Then Naftogaz sought to set aside the award and sought security for costs from Gator, which were then awarded by the commercial court. So this was an application for security for costs against the award creditor. The Court of Appeal reversed the decision, but they were divided, as my learned friend said, on whether there was jurisdiction to award security for costs against an award creditor, where the award debtor was challenging the enforcement of the award. Lord Justice Moses held there was no jurisdiction because an award creditor under a domestic award could not be ordered to give security, and to require an award creditor under a convention award to provide security was to impose more onerous conditions, contrary to Article 3. Lord Justice Burton held there was jurisdiction to make security for costs in respect of an application for enforcement of a New York Convention award because there was jurisdiction to do so in relation to a domestic award. But Lord Justice Ricks gave the leading judgment on the basis that the issue of jurisdiction did not have to be decided, but would be assumed for the purposes of judgment that jurisdiction existed. And it was a long and careful judgment, and it begins, or at least may I take the court to page MS 722, and the middle of paragraph 72, where he said this: above all, there is something counterintuitive about an award debtor being able to obtain security for costs in order to challenge the formal or public policy validity of an award in what are clearly intended to be, in the absence of a challenge by the award debtor, highly summary and essentially quasi-administrative proceedings. If anything, that counterintuition is increased by knowing that in the case of a domestic award, any challenge has to be made timorously by the challenger and at the risk of that challenger himself, by express statutory provision outside the CPR regime required to give security for costs of his challenge. Does it really make all that difference that the challenge comes by way of a defensive response to a move for enforcement, especially in the meantime, as it always remained the obligation of the award debtor to pay the award? May I then take you over to paragraph 77 of the judgment at MS page 723. The award debtor of a convention award may be defending himself against enforcement, but he can only do so by destroying the formal validity of the award, either as a matter of substantive jurisdiction or serious irregularity, or as a matter of public policy. His remedy, the burden of proof of which lies entirely on him, is to show that the award requires not to be enforced because it is not binding or is invalid or against public policy. It may be that the case of a convention award, the court has been asked to enforce, unlike the court of the country where the award is made, is unable itself to set an unenforceable award aside. However, Section 67.3, 68.3 of the 1996 Act, dealing with equivalent challenges to a domestic award, show that setting aside or declaring an award to be of no effect are remedies available in the domestic context. As for the analogous case of refusing enforcement of a domestic judgment because of an allegation that has been procured by fraud, domestic jurisprudence shows that, save in exceptional cases where it may be that an appeal out of time would be permitted, the judgment debtor complaining of fraud will be required to commence a new action. And that was the authority I referred to, that we will try and find over the short adjournment, my Lord. That demonstrates as clearly as anything who in such a case is the substantive claimant, as the analogies of section 67 to 69 of the 1996 Act also demonstrate. If I can go over the page, my Lord, just first column, an inch and a half down. In substantive terms, however, if Lord Justice Ackner's question, are the respondents in the position of the plaintiff is deployed, there can be no doubt as the answer that the award debtor is. In the case of an application to set aside registration of a foreign judgment under Part 74.7, the court can order any issue between the judgment debtor and the judgment creditor to be tried. No doubt the same might occur in connection with an application to set aside an enforcement under Part 62. In such an issue, the award debtor might well be defined as the claimant, effective and formal. Just passing a little further down the page, I therefore respectfully disagree with Judge Chambers' view in Dardania that the exercise of an applicant to set aside an enforcement order is an essentially defensive one, or that the end purpose is not to attack the award, but to attack its enforcement. It is indeed to attack rather than defend, and to attack enforcement by means of an attack on the award.
Why does this matter? What we are concerned with is two conflicting rights: a prima facie right of enforcement under the New York Convention,
Yes, Lord.
and a right, for they are rights, to challenge enforcement on specified grounds, including public policy, fraud, and so on. So all that one is looking at, they're both substantive rights. It doesn't matter who procedurally is in the position of the plaintiff or the defendant. You simply have to work out whether the right is being impeded in a manner inconsistent with the Convention by the proposal to order security, whether it be security for costs against the judgment creditor, or the award creditor, or security for the substantive award from the debtor.
Yes, my Lord. My Lord, I accept that. And of course, when it's an order for security against the award creditor, that clearly, from the authorities, is contrary to the Convention. And we would accept that, because that is putting a fetter on that right.
The argument against you is that the security ordered against the award debtor has exactly the same impact in impeding the right to invoke one of the specified exceptions which entitle you to challenge an award.
And the answer that I will develop, my Lord, is this. First of all, that is, I would say that's expressly permitted by Article 3, because it expressly recognises that procedural conditions can be placed upon the raising of the substantive bases.
Right, but it doesn't matter to that operation which of you is in the position of claimant or defendant.
No, my Lord. What matters? Well, it matters certainly in relation to my learned friend's discretion arguments. It's also helpful in relation to perhaps the way that Article 3 does impact upon this, because what we have is, in the situation that we're dealing with a convention award, my learned friend's submission actually says that it is easier to enforce a domestic award than an international New York Convention award, because you can have, if there is a challenge under Section 68, the payment of security for the award. But what he's saying is you can't. And so that is a disadvantage attaching, I would say, to the enforcement in this country of a convention award that doesn't attach to a domestic award. And therefore that would also contravene the provisions of Article 3.
Well, it wouldn't if that was one of the conditions laid down in the following articles. You're relying on the second sentence of Article 3, but we looked at some authority which suggested that second sentence is really dealing with procedural matters which can't affect the conditions laid down in the following articles. And if the conditions laid down in the following articles represent a balance of interests and define the circumstances in which
security cannot be required, then you can't complain about them by reference to a domestic position.
Well,
Isn't that?
my lord, with respect, no, because it seems to be accepted that, for example, by all the commentators, that a time limit can be placed upon the right to challenge as a matter of procedural law, in which case you lose.
It's because there's nothing in the New York Convention which deals with time limits.
No.
But the point I was putting was really, is there not a scheme here relating to security which
occupied field
buys the field?
Article 6 in relation to security only relates to a challenge in the curial court. Yes. It is not the challenge in the domestic court. So the scheme is not applied to what the domestic court does under its domestic procedure, which is expressly preserved by Article 3.
Sometimes it's an answer to the unoccupied field argument to say, well, the relevant instrument just doesn't deal with this subject. But the problem arises from your point of view when it does deal with it, but on a limited basis, because one then has to ask oneself, well, why has it been dealt with on a limited basis if it was thought that an equivalent remedy might be available in relation to other aspects which it doesn't deal with? That's the whole point about it.
Yes, and as I said before, Professor van den Berg, and we'll come to the commentary after the short adjournment, because I note the time now, my lord, but says that would be an innovation. The actual adjournment of enforcement in a jurisdiction may be an innovation in certain jurisdictions. And so that was something for which the Convention had to legislate. But we would say that imposing security is of the same nature of procedural rule as a time limit, as a strikeout for not providing discovery and so on. And there is one English authority on that I hope to take you to later, my lord.
Shall we look forward to that at 2 o'clock, Mr. Lang?
My lord, yes.